Hi, I'm Curt Levy. I'm president of the Committee for Justice, and welcome to the FTC in courts and Congress. Here comes trouble, and our panelists will tell us just how much trouble to expect. We had to switch the order of the panels because of votes in Congress, so we're going to start out with FTC in Congress first, and then around 5:15 or so, we will go to the FTC and the courts. This event is organized by the Committee for Justice and also the Alliance on Antitrust Coalition. CFJ was founded in 2002 by former White House counsel Boyd and Gray. We are a nonprofit legal and policy organization dedicated to preserving the Constitution's limits on government power and its separation of powers. And central to that mission is ensuring that agencies like the FTC interpret rather than rewrite federal statutes, and that the courts, push back against rather than blindly defer to agencies when they exceed their proper role. The Alliance on Antitrust Coalition is a group of conservative and free market organizations that are opposed to the recent movement to abandon the consumer welfare standard in antitrust and use antitrust more as a political tool. The coalition believes that, that weaponizing antitrust to achieve a, large set of socioeconomic goals would distort the main purpose of antitrust law, which is to benefit consumers, and also would undermine the rule of law in that it's substituting a objective standard with an amorphous and malleable standard that's really unmoored in any at least stringent economic analysis. And I would also say to the conservatives out there that the consumer welfare standard, which has taken hold over the last 40 years, is one of the few areas of the law that's really moved in a conservative direction. And so, we should think hard about throwing that out just because we're, mad at big tech or other big corporations. And on that note, I will turn it over to Stephen Giaier. He's a senior policy advisor and counsel to the Speaker of the House, Kevin McCarthy, and he'll introduce the other panelists.
Thank you very much, Curt, and welcome everybody. If I might plug, everybody should be following Committee for Justice on Twitter. Everybody should be following the Antitrust Alliance on Twitter. Everybody should be following Ashley Baker and her Twitter account too. It is really good information on this and other topics, of course. And should be following Conservatives for Property Rights. I see Jim Edwards there too. Okay, so the first one is Congress and the courts, and Congress and the FTC. And we are pleased to have a exceptional panel here of Judiciary Committee members. The first is Mr. Scott Fitzgerald in his second term from the 5th District in Wisconsin, representing 5th District. He serves on House Judiciary, of course, including the Antitrust Subcommittee and the Financial Services Committee as well, including, and I have to note this, also serves on the Cheese Caucus, which is pure Wisconsin.
Yeah, I forgot about that.
Nathaniel Moran will be joining us shortly. He had one constituent visit to tend to before he arrives here. Should be any minute, but he is from the 1st Congressional District of Texas. He is a freshman on the House Judiciary Committee and the Foreign Affairs Committee. And then finally joining us is Noah Phillips, former commissioner of the FTC, served on the FTC until rather recently. Played an integral role in precedent-setting enforcement actions and regulatory efforts concerning antitrust, consumer protection, and privacy. So here's where I'd like to start. There's the turn of phrase that has emerged in the 118th Congress because of leadership from you and Chairman Jordan and others is the weaponization of the federal government. And a lot of times, a lot of bandwidth has been taken up with agencies like the DOJ, FBI, and Chairman Jordan can list off a bunch of reasons why. One that is sort of, I think, gone under the radar is FTC. And I think people like you and me fully realize that and see it firsthand. Well, maybe not firsthand, but see it. But the public, not quite. It hasn't really gone into the stream of consciousness and into the public yet. that sort of was on fuller display today. When perfect timing for this panel, because just hours ago, Lena Khan was before the Judiciary Committee, of which you serve on and participated. So I guess generally speaking, starting off that way, you are on the committee. How to go? How to play out? Your thoughts on her, we'll call it, performance.
Let me preface it with and apologize up front because leadership has put an emphasis on 20-minute votes mean 20-minute votes, not 45 minutes or 60 minutes. So if they call a vote at 5 o'clock and you see me jump out of the chair and run across the street, you'll know why. So let me apologize up front if that happens. Yeah, I mean, my impression, first of all, would be that I think that both Judiciary, chaired by Chairman Jordan, oftentimes can be, it's a little more chaotic, and I describe it sometimes as a food fight every day of the week, you know? Where in, certainly in financial services, a little more buttoned down, a little more straightforward. You kind of know what you're getting into, I think, before you go into either a hearing or a markup, or certainly when you're taking testimony. But there is a theme and crossover, and serving on education and labor last Congress and switching over to financial services, once again, gave me kind of a little bit broader, I think, view of kind of how Congress can work and how it does work. Also a member of small business last Congress as well. And what I've seen is certainly, I think, under the Biden administration, there has definitely been kind of this emphasis on anyone that has come before any of the committees that I serve on, that there is always an emphasis on some type of social engineering. There's always a piece to any of the opening comments that are made, any of the responses in questions that are being asked by committee members. There's always a part that eventually makes its way to the forefront, and it is specifically about we need to do better in this area or that area. So it really doesn't matter what the mechanics are, what you might see in kind of, blocking and tackling. There's always a bigger cause. There's always a more major goal that's been coming out of almost every agency that I've had contact with. So with that being said, I guess when we prepped for Lena Khan, the chair of the FTC this morning, it was somewhat similar in that you're always trying to kind of figure out, I think, what are good questions to ask, what are very specific things you can try and at least get a serious response on. So this morning, I don't think was really any different than what I had experienced in the past, which is there's always a little tap dancing, as everyone knows happens in any of these hearings when you're interviewing a cabinet level official. But, eventually we got to the point where we were asking questions about, what are the policy goals? And they're not bashful. Oftentimes when you bring up ESG, they say, yes, very much. We're engaged in that. We think it's important. If it means that shareholders are pushed to the back or ignored on certain topics, it's more important to first and foremost consider social justice than it is necessarily about the mechanics of how any boardroom would work. So I thought there were a number of very poignant questions asked by my colleagues in and around that area, and the response is typically what I think you would expect. I mean, we've been part of letters that have been forwarded to the chair's office, and the responses have been, sometimes in the light of, we'd like to work with you, we appreciate you raising the question or the topic, but at the end of the day, very little response. And it's not just the FTC, it's every agency that I think is being influenced directly by the White House right now. So I'm not the seasoned veteran, certainly in this room and in this Congress, but there are absolutely, I think, a number of other members that I've talked to, and certainly Patrick McHenry and Jim Jordan, and you can see when they bring the members of the committee together night before we have a hearing, or in trying to organize where they want members to maybe kind of focus, that that they're well aware of it, and I think everybody understands kind of what's going on in the House right now.
Yeah. Okay, so two things to follow up on there. One, ESG, and the other, oversight letters, broadly. You sent a letter to Lena Khan,
Yeah.
I believe it was December, a few months ago, on specifically
Yeah, it sounds
on
right, December, yeah.
specifically on ESG, and ESG has turned into a major issue within the Republican conference. You also serve on financial services, so you know
Right.
that it's a major priority just this week and just this month with Chairman McHenry. So you're a busy guy generally, and specifically on this issue. So if I recall your comments correctly, she did reply to your letter, but only addressed like half of it, if you will. And you were trying to follow up with her today on the other half. And what happened there? Are you satisfied? Did she eventually?
No, I don't think we got any fuller kind of response, but.
And maybe explain what the two halves
Yeah.
were and what she failed to address.
Yeah, I think, what we were trying to do was again, it sounds somewhat redundant, but we're trying to focus on what are the costs associated with any of these corporations that are simply trying to operate under the same guidelines that they always had. And if you couldn't kind of comply with that, what is the fallout of that? What is the impact? And what the fallout has been is increased costs associated with anybody that's trying to make decisions on a corporation, all the way from a small business all the way to a Fortune 500. And they don't care. I mean, that was kind of the point of the whole discussion, was they really, that is not their goal. Their goal is not to foster business or foster corporations in America. It's to really watch them, and if they think there is some type of violation or any kind of pathway for them to impede and hold somebody's feet to the fire, that's where they're going to go. And that was kind of the second half of the response today, was that was never addressed. Do you feel that what the FTC has been doing right now is impeding the progress of a corporation, or setting them back to make them go back kind of to the foundation of many of the things that they may be working on to advance their own corporate kind of ideology? And are you hindering that? And the answer was pretty much, we don't care. So
Yeah.
it's frustrating.
Yeah. Let me switch to Noah here. While we're on the subject of letters and oversight, congressional oversight, you have experience with congressional oversight. I did not mention in your bio, but you're also a former Hill staffer, and you were an FTC commissioner, so you've seen experienced congressional oversight from both sides there. Within the FTC, maybe we'll zoom out a little bit from there and say within independent agencies, how is congressional oversight received? How does it impact your what you do?
Sure. So first of all, thank you for having me. It's a real honor to be here. Stephen Giaier with the Congressman. It's better to be on the sending end of oversight than on the receiving end. I think we have to start there. That's a very important thing to understand. The independent agencies are interesting for a variety of reasons within our constitutional scheme. Their existence, or at least their independence within the scheme alone, is something that a lot of courts are talking about these days, and people have been writing about for quite some time. But they do have a level of independence from the executive, because the people who run them at the end of the day can't be fired for policy differences. That's where the law is today. It's where the law has been since these agencies were established and then ratified by the Supreme Court in the 1930s in the Humphreys Executor case. But that doesn't mean that they're responsive to no one. And the obvious two sort of parts of government to which they can be responsive, if not to the executive, or to which they will be responsive, are the courts, because sometimes their actions are challenged in courts, and critically Congress. And there was sort of a running joke when I was on the FTC, and I think it had been a joke for many decades before I got on the agency, about how the agency really was a creature of Congress. It would be given directives and funding bills and otherwise about what to do, what to focus on. And the members of the commission would routinely go to Congress. I can't think of how many times I ended up in front of the Judiciary Committee, in the House or in the Senate or in the Commerce Committee. And the FTC sort of has two different committees, in addition to its appropriators, to which it's responsive. The short answer is the agency tries to be very responsive. And part of the reason is that, that's who pays the bills. Part of the reason is that's who makes the law. And part of the reason is it is uncomfortable. If you are a member of a commission, to be criticized by a member, you want to have a good reception, you want to maintain good relationships. You may also have positive goals that you want to achieve in legislation. One of my favorite things that I got to do on the commission was work with Congressman Fitzgerald on a measure that became law, helping the antitrust agencies deal with investments, subsidies that may be impacting companies from countries that are not necessarily friends of the United States. That was a real wonderful opportunity. If you don't build good relationships with people in Congress and you don't maintain those relationships, those opportunities are harder to achieve.
The two of you are segueing to each other beautifully here, because you pitched up for what was going to be my next question, which we are dealing with a member of Congress here who has not only just introduced bills, but he has made law with, in regard to the FTC, what Noah was just talking about. This is the Foreign Merger Subsidy Disclosure Act, which was passed and enacted and signed by the president last year. I guess we're probably around 7 months on from its enactment. Any updates that you've seen on implementation? How's it going? Maybe explain to the crew.
Yeah, I don't think there's necessarily any forward progress necessarily as far as implementation goes that I could describe or kind of articulate for you. But it was once again kind of a bill that I think came together because the emphasis was brought forward. Not only the committee members, but the chairman as well were putting kind of their full strength and weight behind it to try and get it moving. So at the end of the day, again, probably a piece of legislation that doesn't seem so significant that it's going to change things, but certainly I think puts us back on the right track.
Yeah.
So.
And you have also introduced a bill this year because, as many people know, former Commissioner Wilson resigned a few months ago, and so now the FTC is operating in a 3-0 Democrat unanimous membership, although there were two Republican nominees nominated last week.
Last week, right.
So hopefully that will change too, but as of now, it is 3-0. And you have a bill specifically on that, H.R. 3692. And I'll give you the opportunity to plug it here.
I mean, it seems like the value of obviously having two Republicans there now would be obvious, but I will say that, operating at other levels of government and at state, I've been involved in some of these situations where you have, a partisan created committee, and oftentimes they can work together. I mean, there's a lot of common areas that they are able to identify and kind of work to develop policy around or rule, or certainly address the concerns of electeds. But it's necessary to have that balance, and the bill's fairly simple and straightforward and says that you absolutely need to have that balance in place. So, and there might be other ways of achieving that, but the way we did it was the new Republican commissioners will probably have a little more contact, whether it's on Congress and business, and then the media understands it as well, I think, because there's more of a balance there. So I think it makes the FTC stronger. It makes them better able to respond when there are issues before them. So we thought it made sense to draft a bill and get it out on the street.
And Noah, maybe you could talk about a little the importance of the bipartisan 3-2 nature of FTC and its importance.
Yeah, I mean, I think there is a great deal of wisdom in the scheme that Congress came up with. If you're going to have boards and commissions that have some degree, especially ones that have some degree of independence from the executive and thus some insulation from the political process of, requiring regular report cards through voting on the conduct of government, then I think having additional accountability is important. And one function that commissioners can serve, and I think this is especially true when you have commissioners who come from different sides of the aisle, is a level of accountability. Now, just to be clear, I think it was the first dissent I ever wrote when I was a commissioner, it was a Republican chair joining two Democrats. I think they got the law wrong in that case, and the Second Circuit agreed with me. But there's an accountability that attaches not just to party. But I do think a diversity of viewpoints, which having people from different parties effectively enforces, commands, is really important to getting the work right and to having that accountability.
Is a 3-0 unanimous posture, or for lack of a better word, is that detrimental in an Article III court at all?
That's harder to tell. I don't think we have data that show that sort of decisions by commissions that are just, composed of members of one party, do more poorly when they're up on review. We don't have that much data of how things go on review just because the N is not that great. The underlying number is not that great. To me, it's less the court looks at it, well, let me also say this. Litigation takes a long time. The development of a case that goes up on appeal or somehow other than that is challenged by a court, let's say a collateral attack, that's often a very long process. So the people who are on the commission when you start with it may not be the same people who are on the commission when the court considers it. That's a real thing. To me, it's more about the input to the process, right? It's more about the trade-off that sometimes goes on, the exchange of ideas that sometimes goes on, that leads to whatever action the commission takes. In a good commission, you've got meeting of minds, right? And sometimes clashing of minds. And hopefully there's real receptivity to the ideas of others. And at the end of the day, the work product that's able to get the votes of those members, who are selected for their qualification, is work product that will also withstand judicial scrutiny. That doesn't always happen, but I do think the likelihood is higher when it's going through a process of real scrutiny.
And I just realized by invoking Article III courts there, I probably bled into the next panel, which is the courts and FTC, so that's my mistake. Let me reel this back into Congress. Let's talk.
Can I just
please go ahead. Yeah.
I mean, there's such a value in a 5-0 vote also, which I think is, sometimes when you're involved in a situation where there is kind of polar opposites developing strategy and arguments, and then when that's offered in a public venue, and then at the end of the day there's compromise that is developed and it's very evident to everybody that's in the room, certainly at that point there's almost if you create that glide path of a unanimous vote on something, it just obviously raises the credibility of whatever they're working on. So it's another reason I think that if I was serving, I would feel much more comfortable in that environment, certainly, than I think even the commissioners would be on a 3-0 panel. It just doesn't work as well.
Yeah. On the issue of mergers, by my count, I could be wrong here, the FTC under Lena Khan does not have a very good record in federal court right now, challenging mergers.
That was brought up today.
Yeah, good. 0-4, I believe.
Yeah,
was
right,
that, is
right.
That, yeah, okay.
I think that came up, yeah.
As recently as just 2 days ago with Microsoft Activision,
Right.
which a federal court has now signed off on, but I guess they made news yesterday that they're going to appeal that. Let me ask Noah, how common is that?
So it's not that common.
Okay, there you go.
Answer.
Okay, moving on. Not that common.
Well,
Well, it was brought to light by one of the members that,
fair enough. I want one of the, well, let me say the following.
we can move on if you don't want.
The agency sometimes doesn't win its cases.
Yeah.
And sometimes that comes, like right now, we've definitely seen some high-profile instances from both agencies of not winning cases. Sometimes those cases started earlier in development. I do think it's important to take that into account. That was the reason for my hesitation.
Gotcha. Okay. Not that common. Okay. Good. We're not good. Regardless. Owen for Microsoft, Activision, Facebook, Within, right? These are all of public record. Reason I bring it up, you and Mr. Moran and a couple others sent a letter to Chairwoman Kama, I believe in March, on mergers and acquisitions. What were you seeing in agency action that sort of caused you to send that letter? How did you gauge her response? And I will I guess sort of give her credit in this regard. She did respond to the letter, to both your letters. Now, quality of response, I'll leave that to you, of course, to offer your opinion on that. But anyway.
Well, just that the FTC's view right now is that IPOs are the way to go and mergers are not. And if there's any way that the FTC can influence that process or anyone thinking of moving in that direction, they will. It's a way of devolving power and changing corporate structure. And that's what her goal is, and unfortunately that means that's kind of where the FTC is. So all the resources and effort and the momentum in the FTC is to do just that. Continue to I guess I would call it manipulate.
Yeah.
So, and I don't know if your experience is that, in the past when these things would come up, if that's kind of where everybody, if those were the same considerations given, but I think that's where they're at,
So one of the times I was before you, Congressman, in the House Judiciary Committee, this was before some of the big legislation in the last Congress had been proposed. One of the big topics was mergers. And one of the things that I said was that M&A has a really positive role to play in society. Like, it helps companies grow. It can help marry resources and achieve things that can't be achieved without the merger, whether those are economies of scale or the integration of firms at different levels in the supply chain. Critically, and also, and this goes directly to the Congressman's point about preferring IPOs, when you are a startup, when you are an early stage company, there is bankruptcy, there is M&A, right? And there is growth in maybe IPO later. The IPO route is very, very rare. It just doesn't happen a lot. It's very expensive. There are regulatory problems to it. And as a result, right, there are also some companies that may not be equipped for whatever reason to go to market, to the public markets. It's also really difficult, by the way, to be a public company. It's just harder to operate a public company than it is a private company. Ask any CEO, any board member. For most, it's M&A. And the incentives that M&A creates of the venture capitalists, right, to put money into firms that would grow is so important for the innovation in our economy, right? Whether you like particular companies or not, I think we would all agree that Silicon Valley and what has happened there over the last 40, 50 years has been kind of an economic miracle. It is certainly something that they want in Europe, right? That they kind of have in Israel, that they want in Asia. We have that in part because we have allowed exit, because we have allowed venture capitalists to build investment portfolios where some things fail, but some things succeed. And that's capitalism, and that's risk-taking. And I think I have always felt, and I certainly felt as a commissioner, that while stopping mergers that are likely substantially to lessen competition, which is what the statute says, is an important thing, there is a countervailing issue that we need to consider. And going too far can prevent some of the really important incentives that we have that keep our economy chugging in a really good way. And it's just really important to keep that in mind.
And we have that because we have the body of law, of antitrust law, that we have in this country that other countries do not. That began, we'll put in air quotes, began in the 1970s with Robert Bork, antitrust paradox, right? And it's brought along, because it wasn't always that way, right? In the 1930s, 40s, and 50s, it was a very different system than we have now. One that probably wouldn't, I may be speaking a little too big here, I don't know, but might not be conducive to a Silicon Valley growing to where we are today.
Yeah.
Right?
I would say, I think one of the other things that's come up kind of in committee is some members have been kind of focused on, we're not always referring to these massive mergers that grab headlines on the front page. I mean, there's much more subtle, and sometimes they're driven more by industry likeness or a common kind of production that may happen, even like light manufacturing, where you've got some of these corporations that are merging. An IPO isn't appropriate, and that's why I think, it's kind of, we're having a discussion at a higher level than typically I think what maybe happens actually on the street when it comes to some of these mergers that eventually have to be, end up in some capacity in front of the FTC.
Did you have something?
I was just going to say, if you look the overwhelming record over time, if you take as your denominator the number of transactions that are filed for the agencies to examine, and sometimes the mergers they go after are not filed, small hospital mergers and things like that, the agency ultimately does nothing on almost all of them. And in part, that's not just a resource question, it's because most of them present no issues whatsoever. And so they're both not a threat for competition, and they present all of these other benefits. And that's really important as we're calibrating really anything in this space to keep in mind.
Yeah. I think I saw a recent statistic that over 50% of small tech, their goal is not to become big tech, it's to be acquired by big tech.
The likelihood that you end up with a unicorn IPO is very, very low. We love that. We celebrate that. It's terrific.
Yeah.
But it just doesn't happen that much.
Right. Right.
And it doesn't mean there isn't a going concern. And you also, again, have to think about the downstream effects. There's a really beneficial thing to the, to the entrepreneur who's able to sell out and then put that money to good use. Elon Musk is on his 16th fortune at this point. He was there with Max Levchin at PayPal and others, right? And they turned those fortunes into additional fortunes by providing things that didn't exist in the world.
Let me ask you this, Noah. Obviously, the FTC news that makes the headlines have to do with the large Fortune 500 companies, right? The challenging a merger for some big tech in Silicon Valley, or some financial services firm in Wall Street, or some pharmaceutical company in New Jersey, right? Most members don't have a Fortune 500 company in their district, right? But they're affected by FTC actions. And I'm sure you, as a commissioner, got to travel throughout the country and visit with all sorts of corporate entities, big and small. Sort of explain in your experience, in your real life experience, that impact that FTC has, at the hyper local level, if you will, to small businesses that we may not hear about, but members certainly hear about because they live it every day. They're their constituents. So
if you read the news, the cases are almost all about either big companies or otherwise famous companies. Right. When you're on the commission, a lot of the matters, and it's possible that it is trending more in that direction. I haven't done the statistical work there. But a lot of the matters you deal with are with smaller companies. And sometimes smaller companies do things that are bad. Sometimes big companies do things that are bad. The law is supposed to apply evenly no matter who you are. That's true for criminal law, but it's also true for civil law enforcement. But I do think, both in terms of the immediate effect of investigations and agency actions, think about the LabMD case from a few years ago, but also critically in terms of the downstream effects I was just describing, both in terms of M&A, like mergers, but also when the agency goes out and they bring a case, they're sort of declaring that something is illegal. And sometimes the thing is clearly illegal, but oftentimes that's less clear. The last dissent that I wrote when I was on the commission involved a local car dealer here. And the commission took the position that a disparate impact of conduct they were involved in was unfair under the FTC Act. So they basically declared that the FTC Act was an anti-discrimination statute. It's not. It doesn't say that. It preceded all these statutes. That was a local car dealership. And the lawyers, like me, who counsel companies big and small, look to the precedents that the agency sets. Even if we might not agree with ultimately where they're landing on the law, we want to provide them with some level of guidance. Here's where your risk is. right? This is clearly illegal, or the agency says this is illegal, but maybe it isn't. That's really important to companies large and small. If you're a small company, you can't afford fancy lawyers in the same way. If you're a small company, you may not have in-house counsel in the same way. And so we have to think about like an economy that we want that is composed of salesmen and marketers and engineers and designers, less lawyers. And I think that's sort of another really big downstream effect, including for small companies, that actions that the agency takes has.
Congressman, there's another year and a half left in the 118th Congress. What are you and your colleagues looking to do? What else can be done to rein in the FTC here from where you sit on the relevant committee and relevant subcommittee?
Yeah, I think obviously the question beyond oversight, which obviously is main function, big part of what this Congress has been focused on, whether it's judiciary or oversight itself, or the role that any other committees play in oversight. One of the, I think, positive things that happened was that early in this Congress, it was obviously observed, and the Speaker has done a fantastic job of continuing to kind of stick to his guns on we are going to operate in the fashion that the members of the conference want us to. So beyond oversight, we are still very much, despite what you might hear from some U.S. senators, still very much focused on the appropriations process. And there is nothing, obviously, that's going to get, I'm not telling you anything you don't know, there's nothing that's going to get a commissioner or certainly a cabinet level official, nothing's going to get their attention than to work through the appropriations process. Nobody's trying to punish anybody, nobody's trying to lessen their ability to function, but I think the one thing we are trying to do is make them accountable. And many of the chairs, along with the Speaker, have continued to say, that's a role we're going to take seriously. And so the FTC falls into that category, certainly. So, it came up this morning with Chairwoman Khan, and I think will continue to come up, that prohibiting appropriations and the funding is something that, the Congress is going to continue to take a look at. Again, we're not trying to force anybody or hammer anybody into the position that we hold. It's just, when they go beyond kind of where they should be, I think it's fair for the appropriators and the rest of the conference to have a say in just how are these agencies operating. So,
no, I'm going to ask you a question here about. Well, let me just ask this. I asked. While the congressman gets situated, let me ask former commissioners. I also asked this of another former commissioner, Josh Wright, not that long ago. If let's say it is perhaps a staff member for a member of Congress who may or may not have gone to law school, who has at this moment in time a more general or limited knowledge of the subject matter that we're talking about here, what is one book, law review article maybe, or text that you would recommend for them to read to get a better understanding of the law, of the economics, of the state of play of antitrust law and policy in the United States?
So the answer is easy. It's Greg Worden's new book, and I think it's called Foundations of Antitrust. I know it has a picture of John Sherman on the front cover. Greg is incredibly erudite. He had been a senior official at the Department of Justice's Antitrust Division forever and a half. And it's a real great historical survey and legal survey, and very, very easy to read. Very well written, which I always appreciate.
That's good. Yeah, that's good.
I'm writing that down. Congressman Moran, welcome.
Thank you. Pleasure to be here.
It's good to see you from Texas 1st District. That's East Texas.
Yes.
Yeah. I asked the congressman to start us off here. I'll ask you the same question, which is how to go this morning from your perspective. You serve on the Judiciary Committee, of course. Had Chairwoman Khan before the committee. From your perspective, how'd it go, and what are your takeaways?
Yeah, I'll give you a couple of takeaways. One, I was really dismayed because we see a lot of witnesses come through judiciary and the other committees that we're on, and some of those witnesses, are they're going to disagree with you, but they're going to answer the questions. Some of the witnesses, unfortunately, come and they just avoid answering questions. We saw a lot of that yesterday, frankly, with Director Ray. But today with Director Khan, what bothered me was she came across to me as frankly smug about the questions and the differences of opinions that we had. And we can have differences of opinion, but when you start with a premise that you are intellectually smarter than everybody else in the room, and that the differences of opinion are dismissed immediately before answering the questions, then you can't really have a substantive conversation. And that's unfortunate. And, I've got colleagues I know, they use their 5 minutes to typically monologue. I don't like doing that. I actually like asking questions. I've got a lot of questions. As a lawyer and a former judge, I like to ask questions. And I have honest questions that I need some help understanding. But frankly, we weren't getting anywhere today about that. By the time I got to ask questions of her, what I really wanted to focus on were things like the consumer welfare standard, the things that have been talked about quite a bit throughout the hearing and the early terminations, and the focus of the FTC to focus on rulemaking instead of frankly doing their job. That's what they should be doing, instead of trying to impose new regulations and rules. And one of the concepts I brought out, and I can come back to this, I'll keep it as short as you want, or as long as you want.
The floor is yours, go ahead.
But one of the things that I brought out was that, when she moved away from that consumer welfare standard, then you're moving the goalpost. And nobody knows really what's going on. And businesses, when they're looking at trying to make decisions about whether or not to engage in a merger or an acquisition and move forward in some of those transactions, they have no surety of the process. And businesses across the board in so many areas since I've been elected have said to me, we just need to know what the rules are. And we need to know the rules aren't going to keep changing, because we can make decisions on any set of rules, but we really just got to know. But unfortunately, the FTC is leaving businesses in a situation now where they don't know what the rules are, and they don't know if they're going to get an answer yes or no, or get delayed for a reason that's outside of some reasonable standard. But now it's just we don't like your type of business, so we're gonna put you off, and then we're going to tell you no, and we're not really going to tell you why. And oh, by the way, we get to be the judge, jury, and executioner, because we get to play all sides of the equation when we go through this administrative process. So it was really unfortunate. I reminded her of the DuPont decision back in 1984 that says, and I've got the quote in front of me. I still have my notebook, because I left that hearing and went to several other events and showed up here, and I still have my notebook with me. But it actually says, look, this is what the Second Circuit said in 1984. Quote, the commission owes a duty to define the conditions under which conduct would be unfair, so that businesses will have an inkling as to what they can lawfully do, rather than be left in a state of complete unpredictability. I actually think that's a great way to summarize where the FTC is right now, is businesses are in a state of not knowing what the rules are, and so they have complete unpredictability.
And so the Second Circuit is New York City, right? You don't represent New York City. You don't represent Silicon Valley. You represent East Texas. But what they are doing is affecting business in East Texas.
That's right. Yeah, absolutely it is. And I've had two major businesses in my first 6 months. One of them this week that didn't know that I was actually going to have an FTC hearing. On Monday, I was talking to a business from back home that said, you wouldn't believe how many times we had to redo paperwork and restart things on a very simple sale of a section of their business for the FTC. It ended up taking years to get done. And in the process of that, millions and millions of dollars more for attorney's fees for them, and not having that surety about whether or not it would or would not actually go through. And he said, I don't even know if they looked at the paperwork. The stuff they were asking for had nothing to do with the transaction at all. And so, to see that happen to a homegrown business back home, you're just like, this should not be happening. And we're not talking about the industries at the top of the rung. We're talking about industries that are family industries that have grown up, and now they want to sell off a section.
Yeah.
Yeah.
No, did you want to jump in there with something?
Sorry.
No, not at all. So it's literally this week, actually today, I was counseling a client that wants to be on the right side of the law. They have a business idea and they want to pursue it. And it implicates guidelines that both agencies, the FTC and the DOJ, have had on the books for decades and that were pulled down a few months ago. As a lawyer counseling a business, that makes it a lot harder. We have to say things like, well, you used to be okay, but now we can't give you that assurance. And it really is. It's not just Wall Street. It's not just Silicon Valley. It's everybody doing the right thing, trying to stay on the right side of the law. That case, DuPont, from the 1980s, is one of a series of cases where the agency is trying to use its standalone Section 5 authority. What's illegal under the antitrust law that we enforce outside of the bounds of the Sherman Act? The agency pulled down a bipartisan policy last year, and they've introduced a new one, which, as a lawyer, makes it very hard to counsel, which takes a really strong view and implicates precisely this problem. So it's very appropriate that you're quoting the DuPont case.
No, the most recent case from the Supreme Court regarding the FTC Axum. What do you see as sort of coming out of that, and maybe explain what the case is, what happened, and how that might affect Congress, congressional oversight? What should we be thinking about on the congressional side?
Sure.
In the aftermath of that case.
So Axon is a merger case. It's what's called a consummated merger case, meaning the agency brings the case after the merger has already happened because it wasn't notified to the agencies. It's a merger to monopoly, like the underlying conduct, not good from an antitrust perspective. We all voted to bring that case. But that's not what the Axon case is about. So Axon complains about, it has a series of constitutional objections to the FTC structure and to its process. And what Axon did is they brought what we call in law a collateral attack. They didn't want to wait until everything was done at the FTC and the only avenue for recourse was an appellate court, which is what the statute says. So they went to a federal district court and they complained. And then they went to a federal court and eventually this got to the Supreme Court. And what the Supreme Court held 9-0, right? Not a Sotomayor and Kagan and Jackson, was that where it's a constitutional quibble with what the agency is doing, you can bring this collateral attack. You can bring this attack from another court. So what we have already seen, what we are going to see more of is companies that are subject to the FTC's processes. In particular, it's Part 3 administrative process. That's your judge, jury, and executioner. Bringing claims in federal district court complaining that the agency is unconstitutional or what the agency is doing is unconstitutional in one way or another, and we're seeing a lot of that. This is also happening at the same time that not just with respect to the FTC, but with many agencies that are structured like the FTC, a lot of these constitutional claims are getting serious audiences and credence in courts like the Fifth Circuit, which covers Texas, among other states. Where I once clerked, for the record. So I think we're going to see more of those collateral attacks on agency processes. And, ultimately we'll see where the Supreme Court lands on some of these constitutional questions, but they're not frivolous questions. They're real questions, and they're being brought up in cases every day.
Congressman Moran, I'm going to give you the last question here. It's nearing 5 o'clock. At 5 o'clock, we all know it's vote time today. So before we depart here, I asked the same question of Congressman Fitzgerald here. You're on obviously the relevant subcommittee, or relevant committee and subcommittee at the Judiciary Committee. What are you going to be keeping your eye out for the next year and a half as far as FTC? What are your priorities? We referenced the letter that you and Mr. Fitzgerald sent a couple of months ago regarding M&A. What is you're going to be your focus going forward here?
Yeah, well, as anybody that's involved in these processes know, you start with a letter or a conversation, and then you start backing those concerns up with additional testimony like we saw today or getting it out, and then additional groundwork to build a case that says, no, really, that concern we cited in the letter, that really is an important concern and really has to be addressed. So what I anticipate happening over the next year and a half in this session is that we're going to stay on top of them about what are they doing in these cases. In particular, my concern, biggest concern, is this consumer welfare standard where, so really which elements are being applied in which cases, and how are you selecting to choose cases that you're going to move forward with, and then how are you going to determine those on which elements, so that then we can, because today she kept saying, well, it just depends case by case basis, we're going to look at this statute sometime and this statute sometime. Well, we need to have an understanding. The only way you get that is over time, as you see it applied, then you'll begin to see what their real goal is, I think, and what their real new standard is, even if they won't define it as a standard. And once we begin to see that, then we can address that and say, no, we're gonna have to come back and we're gonna have to statutorily fix that. And frankly, I think that's what we need to start moving towards, is find a statutory fix to say, this is the standard. Don't let them do it as an executive agency. Don't let them do it. Again, even if you like it or you don't like it, businesses have to have surety. The only way they're going to have surety from administration to administration is if it is for certain in statute. So we need to have that standard down that is business friendly, because that was the other thing that was clear today in the hearing was she does not have a business friendly perspective on the world. I owned a staffing company for a while, and today the discussion on eradicating non-compete agreements, I'm just blown away every time I hear it. That somehow when you talk about an even playing field to allow businesses to grow from small to medium to big, that you're going to get rid of non-compete agreements. She said, well, except in the cases of, minor cases of sometimes when you actually need that for a sale transaction to go through. That doesn't work. I was in the industry where all those relationships that my salespeople were building were critical to the business I was building. They had no risk in the business, but I had to pay them to build those relationships. If there was no non-compete agreement, they can go right down the street and work for my competitor and take all my business overnight because they have the relationships. And she doesn't understand that because she's never actually worked in a business. She's never actually owned a business. She's never had to make those decisions. So I want to see us continue to push back on all of those aspects over the next year and a half and get something locked down in statute. I want to see that in a lot of different areas, because I think administrative action is way overdone in the executive branch, is intruded in the legislative branch, sometimes by force and sometimes because we're too chicken to do what we need to do on this side of the aisle and actually get legislation passed.
Well, we need to let these guys get to the floor to vote. Thank you to all the panelists. Thank you to Committee for Justice and Antitrust Alliance, and stick around for the next panel.
Thank you.